Welcome, welcome, welcome. Thanks so much for joining us on this really special occasion for us, the launch of the 2021 report of the ASIL Task Force on Policy Options for U.S. Engagement with the ICC. We're very excited at the Society for this much anticipated arrival of the launch day. This report and the extraordinarily broad stakeholder consultation process that accompanied it is a testament to one of the Society's greatest contributions, bringing to bear the highest quality expertise to the most difficult questions of international law and policy. So it's been over 12 years since ASIL President Lucy Reed convened a task force on the same topic, chaired by Ambassador Will Taft IV and Judge Patricia Wald, to produce a set of recommendations for the then newly elected Obama administration. I think we can all agree that much has shifted over the intervening years, and in 2019, President Sean Murphy commissioned this task force with the generous support of the Open Society Foundations. Chaired by Beth Van Schaack and Todd Buchwald, who we'll hear from momentarily, this task force was charged with offering recommendations to the U.S. executive and Congress for fostering pragmatic engagement with the ICC. I have the great fortune to be here as president to commemorate the occasion of the task force completing its work over the past 15 months. There are many to thank for this endeavor, but let me start with the task force members, David Bosco, Sandy Hodgkinson, Sarah Muhammad, and Alex Whiting, as well as the esteemed advisory group, who you will find acknowledged in the report. I also want to take a moment to thank the remarkable Ben Batros for his management of the project, and my wonderful colleagues at Tiller House, without whom, as usual, none of this would be possible, especially our Executive Director, Mark Agrast, and Deputy Executive Director, Wes Rist. So, to the festivities. Our brilliant co-chairs are true experts in the field. Their full profiles are in the materials, and I will be scandalously brief in my introductions today. Todd Buchwald, who I had the great pleasure of engaging in many conversations during our time at ASIL together, is the former ambassador and special coordinator for global criminal justice at the U.S. State Department. Professor Beth Van Schaack is the Leah Kaplan Visiting Professor in Human Rights at Stanford Law and served as Deputy the Ambassador at Large for War Crime Issues in the Office of Global Criminal Justice at State under Secretaries Clinton and Kerry. Todd and Beth will start us off with some brief remarks, after which we'll have a roundtable discussion. We welcome questions from participants, so please do use the Q&A function, and we'll get to those in the final portion of the event, but please go ahead and start submitting those questions. And in the chat, you will find the link to the website where you will find the full text of the report and other acknowledgements, etc. Beth, Todd, welcome. Congratulations. Over to you.
So let me start. So thank you, Catherine, for that very nice introduction of us and the report, and for your support and the support of the Society to this work that Beth and I have been working on for, as you say, over 15 months. And also immense thanks to Mark and to Wes and to Jimmy and to and also to Sean Murphy and the members of the task force, Sarah, Alex, David, and Sandy. All of them were really just terrific people to work with. And also to Ben, who has been just both tireless and fabulous in putting this all together, and to the advisory group as well. It's exciting to see, seeing in the names of the participants here, so to see so many of you, even though I don't actually see you. But it's nice to feel your presence out there on the Zoom call. I'll be very brief so we can have more discussion. The basic idea of the project was to, as Catherine says, to provide pragmatic, with a big emphasis on pragmatic options for the United States to engage with the ICC and address ICC-related issues. And we started work, as she says, over 15 months ago now. And if you think about what that means in terms of some of the tangible things that have happened in those 15 months, from the perspective of issues that are important to the United States government, the appeals chamber overturned the earlier decision of a lower panel of judges, the pretrial chamber, to authorize the investigation of the situation in Afghanistan, which encompasses obviously allegations of torture against DOD and CIA personnel in the early 2000s, and is a force was a prism through which the United States government ends up seeing so much of the ICC, for better or worse. an ICC panel, different ICC panel ruled that Palestine is the state party for Rome Statute purposes, so that it can confer jurisdiction to the court, and that its territory includes Gaza and the West Bank, including East Jerusalem. That happened in the last, in February and March. And there was a review process, which is really still unfolding in The Hague, including a massive report, which I recommend to all of you. It's really long, but it's really good, or really insightful. The independent expert review chaired a panel of 9 experts chaired by Justice Goldstone, which showed that separate from the issues which were of greatest concern traditionally to the United States, there's a lot of issues of concern to ICC supporters and things that the ICC is working out. There were also elections. There was an election of a new prosecutor, Karim Khan, whose role as prosecutor will undoubtedly be key in the direction that the ICC takes in the period going forward. But while it's obvious that his role will be key, what he does will be key. We don't actually know what he will do. There was also an election of 6 new judges, 6 new ICC judges at the Assembly of States Party meeting in December. And there was also an election in the United States. It was widely covered in the press. Many of you have read about it. And that's important for people like us who were mandated to make recommendations that were pragmatic. Because the truth is that because the different administrations would almost certainly have a different sense of what they would consider pragmatic. So it was against that backdrop that we did all our work. We felt that in order to be pragmatic, that meant taking certain things as givens, not necessarily that the task force or that everybody on the task force would think it was a good thing. For example, the idea of the United States ratifying the Rome Statute, we didn't go into that. People have different views, but it's not sort of in the cards as something that's going to happen. So things like that. There were, and the United States is not going to say, "Oh, Afghanistan, it's fine with us." It's just, you could think it should happen, you think it shouldn't happen, but it's not what's going to happen. So there are certain realities that sort of push in one direction, but there are other realities that we should also think about that push in sort of a different direction. The new administration is not going to say, it's not going to believe that accountability for atrocities is unimportant. It's not going to say that human rights is unimportant. It's not going to say that the rule of law is unimportant. It's not going to say that working cooperatively and constructively with our allies is unimportant. And so these are also all things that are going to shape inevitably the way the United States in the new administration sort of works through these issues. And we try to come up with ideas for ways that would resonate with all these broader interests that's consistent with the idea of the United States holding itself to the world as a constructive partner, engaging constructively with partners. And the report, as you'll hopefully read, is an effort to sort of integrate all those things and put them together in a way that that makes sense. Beth, should I turn it over to you?
Sure. Yeah. As you'll see, good morning, everyone. Good afternoon. It's really great to be here. And I just echo Todd's thanks. It's been a tremendous process. And thanks to so many of you who fed us ideas and met with us over the course of this project. So you'll see the report covers really a lot of ground. And we really do welcome your thoughts and views on the report when you've had a chance to digest it. The online version allows you to jump around to the different sections. So depending on what you're interested in, it should be easy to find. In addition to capturing the long history of this evolving relationship, and trying to identify the full universe of interests that are implicated by the US ICC relationship, we come up with a set of recommendations, which we've grouped roughly into sort of 4 buckets. The first set of buckets were really geared toward kind of initial first steps, the goal of clearing the air, recasting the tone, dispensing with some of the vitriolic rhetoric that so characterized the Trump administration. Not surprisingly, and without the benefit of our report, the Biden administration has largely proceeded along these lines, approaching the court as it would any other sort of imperfect multilateral organization in a way that enables it to work constructively at the multilateral plane, but also in ways that won't alienate our friends and allies. For several weeks, we had 2 different paragraphs written on the revocation of the executive order, and we were really pleased to be able to scrap the 1 paragraph that recommended that that order be immediately revoked. The second bucket of recommendations concern constructive steps that could be taken around atrocities prevention and response, regardless of what the current state of the ICC-US relationship is. And these are multifold. I think there's 18 of them. Some are really independent of the court, which include things like continuing to invest in the complementarity norm and to help strengthen other nation states' ability to engage in genuine transitional justice processes, maintaining an autonomous and strong Office of Global Criminal Justice, deploying US law enforcement with respect to perpetrators that fall within our jurisdictional reach, drafting a crimes against humanity statute to fill a really obvious gap in our penal code. And then some of these recommendations that we really are supportive of, regardless of what the relationship looked like, do concern the court. For example, we should be attending the assemblies of states parties and other meetings, working with our friends and allies, putting forth and testing our arguments, getting their feedback, continuing to refine our positions. We should be following and maybe even working to shape through an amicus practice or otherwise the jurisprudence of the court. We should be contributing to witness protection efforts through the court and through other processes. These individuals are incredibly vulnerable, and we should not be wasting political capital sort of fighting about random references to the court in UN resolutions. And our diplomatic mission should be tasked with engaging with court actors if they're in their midst in order to keep track of what's happening with the court. Our third set of recommendations, which I know we'll get into further, concern the more acute issues, and Todd has recognized them: the Afghanistan ongoing investigation, also Palestine, where there have been movement, and then this effort, a larger effort that's independent of the US on reform of the court and reviewing previous court achievements and really disappointments of the institution. And then our final set of recommendations turn on the question of whether or not the United States would be in a position to provide broader support to the court for particular situation countries. And the administration has already indicated an interest in doing so in what it described as exceptional cases. But there are so many situation countries where the court is active in various capacities that are entirely aligned with the United States' approach to atrocities and prevention and response in those particular countries. And so we need to be there are ways in which we could be supporting the work of the court, particularly where it's the only option for justice in those situation countries. Now, in saying these recommendations, we're obviously quite mindful of the reality that given all of the competing interagency equities involved, that it might be difficult to return to the peak levels of cooperation that were achieved under the Obama administration, given the progress that has been made on the Afghanistan and Palestine situations. But we're still hopeful that a sort of equanimity can be reached vis-a-vis US policies. And there's a sort of overarching recommendation, and then I'll close. The United States has and should continue to have a really robust atrocities prevention and response policy. This should encompass a variety of national, regional, and international institutions, including the ICC. And it's critically important that our relationship with the ICC not overshadow or stand in the way of our support for robust and effective atrocities prevention and response. And so the US should maintain a sense of sort of perspective, even with respect to the two situations of concern that move forward. So I'll end there, and I really look forward to our discussion and any questions that emerge out of it.
Thank you both. So let's focus on some of the themes that you've already touched upon. So of course, the task force report focuses, as it should, on the many challenges to an improved US relationship with the court, including, as you've both touched upon, the existence of the Afghanistan and Palestine investigations. Now, we're all in the process of reading the tea leaves from the Biden administration, and I think, Beth, as you said, there's been some suggestions that it would support ICC activities only in what it calls the exceptional or extraordinary cases. Beth, let me start with you. Why? Why should the United States care about improving the relationship? Why should that even be an objective, given obviously the proliferation of lots of different priorities in international law policy?
Yeah, thanks for that. So despite the recent criticisms that have been leveled against the court, it still is undeniably an important international institution that has a chance to advance justice in areas that are so desperate for it. We're not in a situation where we can continue to build targeted ad hoc institutions. We need to find a way to make this court effective. The victims of the world cry out for it, issues of deterrence, the rule of law, human rights, etc. It's the court that we have, and so we need to find a way to make it effective. And there will be many times where the ICC will be the only option for accountability, precisely because the territorial state is implicated in abuses, and the individuals may not be traveling, so we can't rely on principles of universal jurisdiction in third states to do this work. And so we have to find a way to make the court functional, one way or the other. And the US, as I mentioned, has been supportive of accountability in almost all of the situations in which the court finds itself working. We have roles that we can do supporting victims. This has been a long-standing rhetorical point, and we have invested lots through our programmatic efforts in supporting the work of victims, organizing victims, helping them to achieve justice, and also working with national systems to improve their rule of law and their own ability to do this work. But the ICC exists as part of this larger system, and there are times when it will be the only institution. And so we should not be working in acoustic isolation with it, but rather we should be finding ways to support its work. And then secondarily, many of our allies are still very committed to the court, even though they have their concerns that have been fed into this independent expert review process. The court is a reality in the international system, and the US needs to find a way to contend with it constructively.
Thanks, Beth. Certainly those themes resonate in terms of accountability. But Todd, let me ask you the same question, the why. Do you agree? You're on mute.
I think that if you look down the list, in virtually every situation where the ICC is involved, it is promoting accountability in a place where we want accountability to be promoted. And if you look back to, it was 2014 in The Hague, and Ambassador Rapp was giving the United States intervention, and he noted that in every situation where there were investigations and prosecutions ongoing at that time, the United States had expressed support. That was before Palestine, the Palestine situation, before the Palestinians referred the situation there. And but it shows how much confluence of interest there are. I think there's a second sort of set of reasons, which is that the relationship with the ICC doesn't exist in sort of a vacuum. It's part of the broader US approach to accountability, human rights, rule of law, working with allies, and having a credible voice on these issues. And we can't let whatever issues we have with the ICC result in a situation where it's undermining the credibility of our voice. That, in a way, is the bigger picture for the United States. The issue of the ICC is sort of one small piece in this broader picture, and has to be addressed in a way that reinforces the bigger goals that we're trying to promote.
Thank you. Let me switch gears for a moment, talk about one of the most controversial steps taken by the Trump administration, and we've referenced this, but the decision to invoke IEPA and determining that the ICC's work constituted, I quote, unusual and extraordinary threat, end quote, to US national security, and imposed sanctions on the ICC prosecutor and one of the ICC staff members. Now, many groups argued that the then new Biden administration should reverse these steps immediately upon taking office. And President Biden has now done so, but not until earlier this month. Todd, let me go to you first. What do you make of the fact that it took that long for the new Biden administration to revoke President Trump's EO and the sanctions? What, if anything, do you make of this? And what, if anything, does this portend for the future of US engagement at the court?
Right, that's a great question. I have to say, I thought it was a mistake to wait to revoke the sanctions. I think they should have done it sort of right out of the box and not let it mushroom into an issue that would then become a difficult issue to sort of deal with. I think that what happened is they got themselves in a position where it was difficult to make a decision. And what it reflects, because it's not really about the sanctions so much, it's really about Afghanistan and Palestine, it reflects how those two situations are going to make it difficult for the administration to do things that might seem obvious to most of the people on this phone call. So it reinforces that those issues are drive a part of the process. That said, I do think there are silver linings in the fact that it was done in sort of a deliberate way. It wasn't just done as sort of we're getting rid of all the Trump stuff. It was done of, we've looked at this issue and we think that this is a thing that needs to be reversed. And if you look at the statements that the president and Secretary Blinken made at that time, they're really worth looking at carefully. They said that the decision was inappropriate. And that is sort of what they said. It was ineffective and inappropriate, but I thought the inappropriate part was really the important part. This is not the way the United States, that's code, I think, but this is not the way the United States should be doing business. They emphasized our support for the rule of law, access to justice, and accountability. But not only did they emphasize it, they identified it as clearly in their national security interest, which I thought was important. And it said, of course, we disagree with Afghanistan and Palestine, the direction of Afghanistan and Palestine. We'll vigorously protect U.S. personnel, but said that we'll address our concerns in a principled way. We should engage with all stakeholders in the ICC process, is what Secretary Blinken said. So I think those are sort of all reasons to be, it wasn't the way I wanted it. I didn't want it to sort of wait 3 months, but they're all part of what I think is a bit of a silver lining that we can take from that.
Thanks, Todd. I appreciate you finding a silver lining there. Let me shift gears, Beth, over to you. I want to talk a bit about, and obviously your stakeholder process was a hugely broad one, including from a lot of key non-US voices. There's been increasing, I would say, criticism of the court in recent years from within the community of ICC supporters, including an extensive report, the Independent Expert Review, last fall that was chaired by Justice Goldstone, with several hundred pages of analysis and recommendations, which many have characterized as deeply critical. Beth, how did your interlocutors outside the US view the US ICC relationship?
Yeah, we really did do very wide-ranging consultations. And if we're looking for silver linings, the fact that Zoom has become so ubiquitous really made it easy to meet with individuals that probably would have been very hard to do had we done it in person, even with sort of an unlimited budget, which of course we know don't exist. We met with people in capitals, in The Hague, in New York, within ICC situation countries. We met with practitioners, diplomats, government, and individuals who had served in government and had had a sort of ringside seat for this evolving relationship between the US and the ICC. And all were incredibly grateful, actually. This is sort of the brilliance of this project, to have the opportunity not only to contribute to our own thinking and to contribute to this ultimate report, but also to better understand how the US-ICC relationship works. What are the different competing equities involved, how the US views multilateral institutions and views scrutiny, frankly, on US actions, and our special relationship with Israel as well. And so they really, I think it was a two-way learning is what I'm trying to say. Everyone with whom we spoke really sees the value of having US ideas in the mix. They see the value of having US operational acumen as part of a system of international justice, and they see the special capabilities that the US is able to deploy in the service of international justice and to potentially support the court. Many mentioned to us how important it was that the US was involved in turning over Bosco Ntaganda, who'd been wreaking havoc in the DRC, and Dominic Ongwen of the Lord's Resistance Army. I mean, it was really, both of those were really remarkable feats that very few states could have probably pulled off in the same way that the United States was able to do so. That said, there were no question that there are widespread and really deep-seated concerns about the direction that the court is in, its pace, this output, its working methods, its strategic direction, the sense of, or the lack of collegiality within the institution and between the various organs. And there's a really strong collective sense that the court needs to regroup and to find a way to be more effective and to be more efficient and to really deliver justice, which is ultimately why the court was created in the first place back in the mid-1990s. And what was really striking about the independent expert report and the critiques of the court that inspired it was that many of the recommendations and concerns in some respects echo concerns that the United States has articulated over the years vis-a-vis, and particularly the Afghanistan situation, that the court and particularly the Office of the Prosecutor is really overextended. It's looking at too many situations and can't build the indigenous expertise it needs to be able to succeed in these very disparate situations, comparing Colombia to the Democratic Republic of Congo to the Ukraine to Myanmar, Bangladesh. I mean, these are all such different situations that require real expertise in-house that's just hard to cultivate. And so while all of those situations deserve the international community's attention, it's really hard to be an expert at all of them for any one particular institution. And so the OTP and other organs of the court need to find a way to focus their energies on situations and individual cases where they can more effectively carry out the mandate of the court. That said, while there was this sort of widespread unarticulated disappointment with the court so far, everyone with whom we spoke agrees that this reform effort is really worth the effort, that the international community is better off with a court, and that we all need to work together in order to build it into the institution that we envision it could be. And everybody wanted the United States to be a part of that process, even if we're on the outside. The famous idea of the US being a bulwark on the outside, if we're not a pillar on the inside, that they want the US to be a part of that process. And so they really welcomed the opportunity to put forward their suggestions on what pragmatic engagement might look like.
Thank you. So let me do a deeper dive on, I'm sure it's one of your favorite topics, which is one of the most controversial, in terms of taking a step back from all of these issues. Afghanistan and Palestine obviously loom large as immediate issues of the day. I think it's certainly fair to say that it had a big impact on the work of the task force. So I'm going to ask you both some patently unfair questions on this point. Beth, let me start with you. How do you think the US government should address the Afghanistan issue?
So we have a huge section on this in the report, and it obviously was one of the most difficult. We actually started this project trying to put these two tough issues to the side and sort of focus on other issues. And we quickly realized that it was impossible, that they're just so intertwined when it comes to US engagement with the court that, that was an artificial compartmentalization. And so we sort of dispensed with that, and we just embraced the fact that we were going to need to come up with recommendations that are going to exist in parallel with each other, vis-a-vis the court in general, and then with respect to these two situation countries. So the Afghanistan situation obviously really touches on the United States directly, because it's our personnel who stand accused of committing abuses. And as we know, President Obama admitted that torture was committed in our name, those of us on the call who are US citizens. And so that's not something to be trivialized. And our report, I think, really tries to be careful about acknowledging how serious the allegations are. We do look at the allegations against the DoD and the CIA somewhat separately, because their postures vis-a-vis the Office of the Prosecutor's investigation, as it has been revealed in her preliminary examination reports, is quite different. There was a formal policy of enhanced interrogation techniques that had top cover coming out of the CIA, whereas at the DoD side, it was more clearly done at a more local level. There was less of a policy emanating from the top. And so one of the things we focus on is encouraging the United States to be more forthcoming about describing all of the ways in which it did respond internally within these two agencies to the allegations once they emerged, and how the prosecutorial authorities ultimately reached a conclusion not to open investigations into CIA abuses, including with respect to the lawyers who enabled those abuses to happen by putting forth legal arguments that have now since been withdrawn. We also suggest that there's much more that can be done to articulate the many non-criminal responses, looking through the lens of transitional justice at measures of non-repetition, the ways in which the US has responded to address the allegations of detainee mistreatment, including a whole range of investigative commissions, some in agency, some external and independent, legal and policy reforms, the withdrawal of the memos, as I mentioned, other steps that were done. And then we encourage the Biden administration to think what more can be done in this regard, including thinking about potential other amends that could be made vis-a-vis individuals who've been harmed. I think the totality of these steps, given the enormity of the crime base in Afghanistan, including the scale and nature of ongoing crimes against humanity by the Taliban and other armed groups, provide us with a good faith basis to argue within the rule of law context that the prosecutor should not prioritize any investigation or potential case against US personnel. And as we saw with the recent closure of the Iraq investigation situation, which involved allegations against United Kingdom personnel, that the objective is not necessarily to establish that the US response was perfect. It certainly wasn't, and I think many on our task force and our advisory group would agree with this, but simply to show that there's an appropriate basis for the OTP not to further pursue cases. At the same time, we also recognize that it's going to be very hard for the OTP to signal this, either publicly or privately. And so the US may need to be able to live with a state of somewhat uncertainty here, where inaction is actually a form of success. And if anyone knows me, you know that I'm a longtime practitioner of yoga, and the essence of yoga is sort of calmness in an uncomfortable position. And I think the US needs to develop that kind of sort of equanimity when it comes with the fact that the Afghanistan situation is going to remain open because there are crimes against humanity happening. And we need to find a way to live with a certain degree of uncertainty there.
Thanks, Beth. I think it distilled down to a calm engagement on that. Todd, over to you. How do you think the US government should address the Palestine issue?
I like the part about inaction being a form of success because I think that could play to my strengths.
Inertia.
Yeah. So the Palestine issue is, it's not going to go away. It will generate significant resistance to having a supportive policy towards the ICC. When the prosecutor, after the court's decision in February, the prosecutor announced the commencement of an investigation in late February, early March, I can't remember. He immediately issued a statement saying he was disappointed, and it wasn't only the U.S. There were other countries. The British, Boris Johnson wrote a letter. The Germans wrote a letter. I mean, this is an issue that has controversy from sort of a lot of different directions. There were letters. I think last spring there was a letter by like 71 U.S. senators about that was intended to sort of bolster the administration to stand up to Israel. The letter was signed 71 senators, including the senator who's now vice president. So this is not gonna go away easily. I'd say in terms of the report, our report was to make pragmatic recommendations for the United States, not for the Israelis. So there was only so much we could sort of do about this, but I'd say a couple of things about the case that I think will be themes going forward. I think that, more importantly, what Secretary Blinken's statement shows is that, is disagreement about the sort of way that the court analyzed the decision pursuant to which it decided that there was jurisdiction over Palestine. The court said, the way I read it at least, that it doesn't matter whether Palestine is truly a state under international law, that it's a special question of whether it qualifies for purposes of the Rome Statute, basically, whether it's a state party for purposes of the Rome Statute. And I think that is a tricky issue for the United States going forward, because the United States has long argued that there shouldn't be jurisdiction over nationals of non-states, of parties, nationals of parties that aren't states, parties to the Rome Statute. And the argument has always been, well, if an American went to France, there would be jurisdiction in a French court, and all the French have done is delegated that jurisdiction to the International Criminal Court. That argument takes as a given that France is a country, that France is actually a state under international law and has jurisdiction that it can delegate. And this decision is saying that doesn't matter. And I think that is sort of a tricky one going forward. I think it'll be very hard for the United States, and I think eventually others sort of accept that line of reasoning, but we'll see. The second part of it that I think is going to be a continuing issue is the logic by which, if you accept the logic by which the court decided that Palestine is a state for these purposes, it all depends on the way the accession process works under the Rome Statute. And there's a big jump, if you use that logic, there's a big jump from saying that Palestine is a state to its second conclusion that Palestine is a state, the territory of which includes Gaza and the West Bank, including East Jerusalem. And I think that gap is a troublesome one, I think. Maybe the most important one is, or the most interesting thought I have about this is, the prosecutor wasn't under her theory of the case, the prosecutor wasn't required to go to the court at all. She went to the court because she reasoned, understandably, that I don't want to invest all these resources into an investigation if at the end of the day, the court might tell me you don't have jurisdiction in the first place. So that makes sense. The decision of the court was 2-1, right? So you have a split decision from a panel that is different than the panel that would eventually decide this if there were a real case. When there's a real defendant before the court or a real request for an arrest warrant, there'll be a different panel of judges deciding it. And the court anyway is sort of like is in this position where it doesn't accept the principle. I think in the reply that the prosecutor sent last week, the week before, in response to the independent expert review report, it noted that in the Rome statute, unlike in many domestic systems, the concept of stare decisis isn't really there. Courts can re-examine issues, or panels can re-examine issues, if they think it's appropriate to do so. So what you have is a 2-1 decision that isn't given stare decisis effect. So in a way, the prosecutor did not get the assurance that she sought, that there was no question about jurisdiction, and still risks investing resources into a situation where the court might eventually decide that there's no jurisdiction. Anyway, I don't know where all this will lead, but I suspect that those 3 strands will be a part of the way the Israelis talk about it going forward. More importantly, the way that the United States talks about this going forward.
Thanks, Todd.
Can I say one other thing? I think that from the, it's hard. All I know is what's in the Israeli press, but you do get the sense that part of what their strategy for dealing with this is a strategy of deprioritization. Right, the investigation exists for now, and I think that is something that is actually sort of a common thread to the way that the Palestinian situation might be dealt with and the way the Afghanistan situation might be dealt with. Okay, we don't agree that there's jurisdiction, but even if there's jurisdiction, this case doesn't rank as in a court with 5 convictions over 20 years or whatever. This isn't the 6th. This isn't the 7th.
Mm. And as you say, the deprioritization, whatever that may look like, is another kind of version of the calm engagement that Beth is going through, and that common strand throughout. Yeah. Okay. So let me, in the time that remains, there's some very good questions cycling in as expected given this audience, but let me ask you to do 2 future-oriented questions, and I want you to peer into your crystal balls on this. Beth, starting with you, so looking into your crystal ball into the future, what do you see as the big picture issues that the ICC absolutely needs to address in order to be successful?
I think many of them were
3. I imagine there's a lot. But.
No, I really will commend the independent expert report process that Justice Goldstone championed. It really was an incredible exercise, and I think that report sets forth a number of important recommendations that are court-focused. Our project was very much not court-focused. As Todd mentioned, it was really focused on the U.S. government and its relationship, and so we had a different emphasis here, but there's lots of places of convergence. It's pretty clear, I think, that court organs, and I think much of this falls to the Office of the Prosecutor in the beginning, needs to improve the ability to do effective investigations in situation countries and framing the charges and then choosing which defendants to pursue. For various reasons, the Office of the Prosecutor is just not meeting the burden of proof that is expected of it by the judges. Now, to be fair, the burden appears to be somewhat of a shifting target depending on which judges are impaneled. And so the judges, I think, need to really focus on their own reasoning. And some of the judicial reasoning has left many international lawyers somewhat baffled by some of the outcomes of the court. And it's pretty clear that there's also a lot of hostility and mistrust, I think, between organs of the court that needs to be addressed by the new incoming leadership that Todd mentioned. And so, there's lots that I think the court can do to get its house in order. But I think there's no question that this string of acquittals, even though, I don't want to measure the success of the court necessarily by its ability to sort of, convict everyone, but the string of acquittals really signals that there are some acute problems with working methods, strategic strategy, et cetera. Now, the current prosecutor has still, again, to be fair, has had to deal with cases that were filed by her predecessor. And I think there's been more success in more recent cases that have been filed under her watch, which is really encouraging. And I'm really hopeful that the new incoming prosecutor, who's a very experienced international criminal law practitioner, Karim Khan, can continue to sort of turn the ship around and improve the prospects for justice in fair and efficient proceedings.
Thanks, Beth. Todd, same question. Big picture issues the ICC needs to address.
Right. So this isn't me as, as expressed in the report. This is just me from afar.
Mm-hmm.
I think I see sort of two sort of mega issues. One is, sort of what's the North Star that the court is setting for itself? And is the North Star, we are here to make sure that no rights of victims go unvindicated? Or are we here to ensure that the most egregious perpetrators of impunity, of people who are shielding those who are responsible, that those worst cases are addressed? And they're both worthy goals, but they're different goals. And I think that the first goal is a worthy goal, but it's not really something that the ICC can credibly pursue. And if they make that their goal, they're setting themselves up for, the court is setting itself up for failure, because it will never vindicate that goal. It can be part of that, part of achieving that goal, but that can't be what drives its decisions. And it's one sort of mega view, or that has to be sorted out. And it's a really hard issue. The second is something that was alluded to in the independent expert report. They have a section on, is the court, is the ICC, should we look at it as an international organization, or if you look at it as a court? And the premise of it is, if you look at it as a court, you're supposed to sort of it's more independent. And I think that, of course, the judges and so forth and the prosecutor are supposed to act impartially, but it leaves open the question. There is a question about how much sort of guidance and oversight that the states are responsible for giving it. And I personally think, the people who wrote that report are more knowledgeable about this than I am, but my reaction to it is that they haven't quite drawn the line in the right place, that there needs to be more of a sense of state ownership of what the court is doing, not to interfere with judicial decision-making, but to sort of, to sort of speak in some ways to like what it is the court, what it should be impartially and independently deciding. In the report itself, if I have one more second, in the report itself, they have sort of two sets of, or what I divide into two sets of recommendations. And actually the bulk of the report is about how well or not well the court is executing its mission. And so, the too many acquittals, and they should be more collegial, and culture, these kind of things. A second set of questions are what it is that they should be trying to execute, what their goals should be. And I think here, I guess it goes back to my first point before, I think here that they need to look at ways to sort of narrow their aperture. That in the report, what it says is it recommends that the court actors should sort of increase the gravity level. The Rome statute says that the court should have jurisdiction if there's sufficient gravity, but it doesn't say what's sufficient. And they have to sort of, they don't say by how much or how to do it, but the concept is that you have to have a higher level. And I think it seems right to me, but I don't think that's the entire story. I think they have to look at all their sort of admissibility factors. And, so when they talk about complementarity, I think there has to be sort of different ways to give deference to national decision-making. And even, well, I should leave it there because I'll talk beyond my knowledge pretty quickly. But in general, I think the issue is, ways to sort of focus their aperture in a way that's more sustainable.
Okay, understood. Let me get to a final question and then we'll open it up. So putting aside what you might personally favor, what do you predict for the future of the U.S. relationship with the court? Beth, let's start with you.
I actually do think, just given the emphasis of the current administration on multilateralism, on working with friends and allies, on being a credible voice on issues of human rights, and really making human rights central to U.S. foreign policy, which was mentioned in one of the questions, I think there's no way that we could remain aloof to the work of the court. I think we will gradually work our way back to a cooperative arrangement. I think, like I mentioned earlier, it may not be to the same level that was able to be achieved during the Obama administration, but even when I was working within that administration, it was still a work in progress. I mean, we were having to work up processes internally to deal with requests for cooperation that would come in, looking at the legislative framework that governs the U.S. relationship and figuring out how we could be supportive and if it was within U.S. interests to do so. And so I would hope that we would get to a point where that kind of a modus vivendi is operative. There will always be situations where harm to victims on a large scale is going to overpower hypothetical concerns we might have about the court, even with the Afghanistan situation open. And, we mentioned this in the report, but the situation in Darfur is really a great example of that, where there was hostility within the Bush administration, lots of tangible manifestations with that. But President Bush cared really deeply about what was happening in Darfur and did not want to see a genocide going unresponded on his watch. As you remember, the famous story of "not on my watch" written in the margins of a memo to him. And so that caused the United States to sort of step back and reevaluate the relationship and ultimately put us on a different path with respect to the court, which the Obama administration then was able to continue along. So I think that's the reality, is that we care too much about the same values that animate the work of the court to not find ways to be supportive of the court, even while we're in a defensive posture, and finding that balance between what affirmative contributions we're in a position to make and then retaining that defensive posture where we feel it's necessary. I think that's going to be the ultimate challenge.
Thanks, Beth. I certainly remember the "not on my watch" moment as being a critical juncture point. And I do wonder what maybe we'll find another "not on my watch" moment. But I read you as cautious optimism in terms of engagement. Is that fair? Yeah. Okay. Todd, same question. How are you?
I think the same way, though I'm probably, it's a balancing act, right? But I think I'm probably less optimistic about where it will fall than Beth. But I think but that's just a guess, right? I think the factors are all the same factors. I think that you have in any decision whether to support the ICC in X country, there's a bunch of pros and cons, and points of doing, points supporting doing it and points of resistance. And the resistance will, or one of the points of resistance will come from whatever it is that's happening in Afghanistan and Palestine. And if those cases are proceeding as if there's a threat there, that'll make it harder. And if those cases are not proceeding as there's a lot of successful inaction, there's a lot of inaction, nothing seems to be happening, and everybody's calm about it, then there'll be more sort of oxygen in the room to be supportive. But even when we're in a case where things are looking bad, where things aren't going well in Afghanistan and Palestine, there will still be, as you and Beth have both said rightly, the sort of Darfur moments, right, where there's just, President Bush looked at these two, he looked at the genocide that was happening in Darfur, and he looked at, his administration's negative approach to the ICC at the time, and he said, I just care about these people who are the victims of genocide more, and that's more important to me. And let the thing go forward. And that will happen again too. And I think it's sort of foolish to deny that there'll be, and it'll be more than just that. It will take less than that to convince people that a particular, I don't think it will require a determination that genocide has occurred in a country to sort of make that happen. But I do think there'll be a lot of resistance unless things sort of smooth out over the two hard situations.
Okay. I don't want to put you on the spot with this question, so you'll tell me if you don't want to answer, but if one of the key deciding factors for you is the inaction versus action on the Palestine-Afghanistan inquiries, what do you think will happen? What do you predict? Are you more in the camp that it will kind of manifest in some inaction that could promote more engagement by the U.S., or is it going in a different direction? Or do you have an opinion on
that? I think that, a lot of people think that it depends a lot on the prosecutor. So I don't know. Yeah. Right? It depends on I don't know the prosecutor. Yeah. I think the fact that that people think it depends so much on the prosecutor is actually sort of like a weakness of the system. Like, why should it depend on what this one person thinks? But it sort of does. And I don't know what'll happen, but I just sort of feel like that's what it's a rational strategy to work towards that for us.
Okay. All right, thank you both. In our remaining time, let me go. There have been some wonderful questions submitted. I've been tracking as we've been going. I actually want to start with something that brings up a theme that we haven't yet touched upon, which is the domestic U.S. Policy and other interests, and how that impacts the engagement question. Obviously, there's a fair amount in the report on that question. One of the pieces, and I recall when Secretary Blinken addressed the State Department, he talked about foreign policy as domestic policy, that we as internationalists, as internationally oriented, needed to pay perhaps greater attention to how foreign policy should be manifest and perhaps discussed as a matter of US interest, domestic policy interests, and how those two intersect, in the sense that perhaps those in power and those that care about US international relations need to change the mode of conversation domestically and talking about international interests and convergence with US interests. So there's a question here and submitted, and it says, what recommendations does the task force have for addressing misunderstandings, polarization of the ICC domestically by the public at large, as well as with other branches of government, such as Congress? Who wants to take that first?
I can maybe start us off. This is definitely something that came up a lot. The fact that there isn't a lot of direct engagement between organs and court principals, and then organs of the court, and then US government entities, or members of the general public. The ABA has done really interesting polling around the US public. And, you know, on an abstract sense, the US is supportive of the idea of an international court, is supportive of the idea of the United States playing a leadership role in these spaces, and even expresses some support in seeing accountability for abuses that are attributed to US personnel in international fora, if there isn't a domestic fora. Now, I think those numbers are somewhat soft, and I think a lot depends on the way the questions are phrased, but the public is interested in these issues, but we haven't really built a strong domestic constituency around these issues. And I think part of that is because many US NGOs have been very externally focused or very focused on working with US government officials, et cetera, and to try and bring about reforms, and hasn't necessarily been focused on the US public. And I think that's some place where I hope a report like this can be helpful, and we can do continuing rollout events afterwards that are addressed more to members of the public, just to answer those questions. But we do recommend that we should be fostering on all sides greater interactions between principals within the court and principals within the various branches of the US government, just so they have a better understanding of how each other operates, how they think about these questions. They have safe spaces in which to convey perspectives and approaches, to convey criticisms of both sides. And I think there's a lot more that can be done in that regard.
It certainly seems to be a key point in terms of domestic audiences. Todd, did you want to say something?
I think one thing, in general, foreign policy needs to be explained better to the American people. I think, in the Cold War with the Russians across the border in Germany and so forth, it was sort of obvious to people. And there's a responsibility of the people who are making foreign policy to explain the stake people have in the policy. In terms of this issue, I think that the thing that needs to be better, more widely talked about and sort of understood, is the statement that was included in Blinken's statement that this is a national security interest. Because I think to people like me and Beth, that's obvious, but I don't think that's obvious to the average person, right, at all. And maybe we're wrong. I don't think so, but maybe we're wrong. But we need to, if that were sort of more widely, if it was true and that were more widely understood, then the basis for the other side of the story would be more deeply appreciated.
Thank you. And so that's certainly one theme, national security. The other is potentially human rights theme. And one of the questions from the audience states, given Biden's stated prioritization of human rights in his foreign policy, what are the best strategic policy arguments for supporting the ICC, despite longstanding U.S. concerns about the court as advancing long-term human rights priorities?
Right. I think that I'm not in the administration, but I think they will likely view this largely through the prism of, we can't act the way our predecessors did because it robs us of our credibility as a promoter of accountability, human rights, rule of law. And I think that they perceive that correctly, that if all there is venom about the ICC, it sort of undermines our ability to do what I think the Biden administration wants to do, which is to engage constructively on a whole range of issues in this area.
Thank you. Let me just take a look. There really are some fantastic questions.
I've tried to answer a couple that I had quick answers for, and apologies for jumping the gun on that, but so
No,
if you
no,
were
not at
interested,
all.
you could check out that column as well.
Thank you, Beth. Let me ask you this. Is there a stronger rationale for the US to participate in the ICC than other international tribunals? Or would there be like reasons for the US to robustly do so with other major courts? I guess the question is, are we talking about engagement with international organs kind of writ large, or is there something special about the ICC that requires the US to look at that in a different way?
In the sort of background materials of the report, we try and trace the way in which the US has in the past engaged with courts. And we know that was very active. I was in the ICTY early on, and I remember the US submitting amicus briefs, for example, lots of operational support when it came to fugitives and otherwise seconding personnel to the court, just engaging regularly through embassy in The Hague with court actors. There were lots of US personnel in those courts. And so there were natural sort of points of conversation that could happen. So I think, the general recommendation that the report makes is that we should continue that with all international institutions, including new hybrid institutions that are getting off the ground in the Central African Republic, for example, that are being contemplated in South Sudan, the residual mechanisms that are still working in the former Yugoslavia and Rwanda. There are still some, believe it or not, some fugitives from the Rwanda situation. One recently has been identified finally after years of being on the run. And so I don't think that there's anything special or particular about the ICC, any more so than these other institutions that are delivering justice for the worst crimes known to humankind. And I would like to see the ICC be considered part of that larger policy mosaic where, international institutions inevitably are imperfect and they make decisions that run counter to our preferences. But to the extent that we have shared values with these institutions, we should be finding ways to support their work and to continue to push the sort of values that animate them together.
Okay. Let me go to this question. How do letters by governments and government officials square with the requirement that the prosecutor and the judges take an oath to exercise their mandates independent of government instructions? Would it not compromise the court to take instructions from national governments that object to particular situations?
It depends what they're objecting to, right?
Mm-hmm.
The rules that the judges are enforcing or making decisions are rules that were written by the states, right? If somebody is a drug trafficker, the court can't pursue an investigation or prosecution. Why is that? Well, because the state didn't give the judges those decisions to decide impartially. So I just think that there is, I don't think it's right at all to, that this defendant is guilty or, like that. But I do think that the states have a role in sort of writing the mandate in the first place. That's the way international law works.
Thank you. We have a few minutes left. I'm looking, and thank you, Beth. I see you're answering a lot of the questions, which is magnificent.
The inaction is a form of
I know we're not going to have time. There's so many rich issues and really terrific questions.
There really are. There really are.
I was going to say the inaction is a form of success. It does not mark that's modus operandi.
That is certainly true. Let me, there's, I think, time for a couple more. There's one that's very, very much obviously my expert in the weeds, but in this recommended calm engagement approach, would the panel recommend further softening the requirement of Article 98 agreements and SOFA terms as prerequisites to military aid, or even contributing to the court's victims fund, perhaps? What do you think about those points?
Todd, do you want to start on the agreements?
I'm not sure I sort of understand entirely the question. I think the Article 98 agreements are there. I'm not sure that any more are being, I don't think that any more are being, they're just sort of there. And they're not really.
It's sort of innocuous, honestly.
Yeah,
they're symbolically there, but yeah. We do raise the trust fund for victims question is a really interesting one, and it deserves more attention. And I hope someone out there can write a paper on this. Diane Amon has started with a blog post, but there is a piece of legislation that prevents the United States from supporting the court directly financially. And that has undergirded our position in the Security Council about having UN assessed funding go towards investigations that flow even from Security Council referrals. That's obviously controversial. The statute contemplates that the UN might be in a position to fund those investigations, but that's where we stand vis-a-vis the legislative framework. But the Trust Fund for Victims, is an independent institution, and it's almost a corporate law question. Although they both trace their provenance to the Rome statute, they have an independent governing board, et cetera. And so one of the recommendations that we make is that the US should take a fresh look at whether or not we could be supporting the Trust Fund for Victims directly. If not, because of the legal constraints that exist, and if Congress chooses not to withdraw those, which might be appropriate under the circumstances, because we have ASPA in place, there's no need to keep this other separate piece of legislation on the books. There's no reason why the United States couldn't continue to support implementing partners of the Trust Fund for Victims that are working in ICC situation countries and that are working directly to help rehabilitate survivors and to rehabilitate their communities. So that is a strong recommendation. And in addition to thinking about witness protection issues, which the US is potentially in a position to provide as well when it comes to witness resettlement for vulnerable witnesses.
Thank you. It's certainly a very proactive way to engage with the United States. So we are at time. Can I ask you if there's any final thought, 10-second thoughts that you'd like to share with this audience?
Just from my point of view, I hope everybody on this call reads entirely the report, and that I think I can speak for both Beth and I, we're interested in what people think about it, and sort of continuing the dialogue and sort of getting your views and your input, because it's the kind of thing that will be forever a work in progress in a way.
And we hope to have further rollout events. And so we hope that you can attend those, and then hopefully we can get to some of the questions that we weren't able to get to today.
Thank you. Thank you both. Just really a magnificent feat over the last 15 months, and a high quality report that surely will have an impact, I think, on US engagement going forward. So congratulations to you. This is really kind of paradigmatic of what the society can do at its best. And so a huge thanks to everyone who is participating, who is engaged in these issues. It's very much appreciated. So thank you all, and we will see you soon.